Okay, let it. Thank you, Chandramouli. Okay. It's a matter of great privilege for me to involve in this academic venture. This is Professor Ramesh, Dean, Faculty of Law, and also the Chairman, Department of Studies, University of Mysore. At the very outset, in the previous days and in the previous sessions, and many scholars have come out with various facets and phases of the human rights. I am here to explain some practical problem that is based upon my practical experiences. In fact, I had come out with some video clip that ran for more than 20 minutes. But unfortunately, because this is in a virtual lecture on the dissemination of knowledge, I could not play it. And sorry for the inconvenience. Anyway, the challenges of human rights in India is a very peculiar when compared to other country. You know that what actually happening in India, because the human rights itself is under dilemma. And the entire lecture, I will be delivering my lecture for 2 sessions, and these 2 sessions and the contents that has been involved in this particular 2 session is based upon experiences I have experienced practically. While experiencing the practically, I have gathered many literature, many videos relating to the human rights. It is not necessary for me to, if I'm correct, to define what is human rights. No, it is not necessary, because majority of the professors in the earlier occasions might have offered various kinds of definitions. But I'm just going to offer just a simple definitions. Human rights means respecting each other, that's all. You just take anything. If any individual, in the absence of ego, respect the other person, I think law does not require to protect his right. So if I respect you people, and I think I can just create an egalitarian society, an Ethiopian society, as the case may be. But it's not happening here and elsewhere also. As I've already made it very clear, what are the challenges of human rights in India? Human rights in India. It may be the problem relating to the child labor. It may be the problem relating to the untouchability. It may be the problem relating to the old age people. It may be the problem relating to the bonded laborers and the depressed classes and the women who are subject to discriminations. Maybe on various grounds. It may be on various grounds, as the case may be. Now, it is very important. No, just one of my students came to me about 10 years back from Bangalore, and she wanted to pursue PhD under my guidance on the child labor. And of course, there are various facets of child labor. And of course, she has opted that I will do, and she said that she will do the empirical study, especially the child labor situation available in Sivakasi, in one of the places in Tamil Nadu. And actually, we went there, and I and that lady and her husband, we went there, and we actually observed by the observation method, as per the research methodology, with respect to the pathetic conditions of the so-called child labor who has been engaged for manufacturing of the firecrackers. So in a Sivakasi, they hire the children from the various local villages, and they need to wake up at 6 o'clock, and they have to be there by 6:30. 2 idli and a sambar and one dosa will be given to them, and they need to work from 7 o'clock to till 8 o'clock in the night or in the evening. And it is very much astonished to know about the remunerations they are receiving. Just 15 to 20 rupees remunerations was being offered to such child labor. So now here, if the localites refuse to send their children to that particular firecracker factory, and they will be punished, and indirectly they will be exploited, and all kinds of harassment will be there against them. And this is what actually we have observed it, and we have gathered the informations too. And we just met the concerned deputy commissioner of Madurai district, and asked him to give the permission to enter into the firecracker factory, but he did not give any permission because it's in a dangerous zone. It's a dangerous zone. That means at any moment, the explosion may take place. That means those who are working in that particular Sivakasi firecracker factory, they always work with lots of apprehensions. No government, see, there is various kinds of policy. And of course, child labor has been abolished. Bonded labor system has been abolished. But child labor and a bonded labor system, untouchability is available in one or the other form. In new form, it is available. That I'm going to explain it because it's a gross violation of human rights, which challenges to the entire government of India and the state government. And this is the very pathetic situations we have come across in Sivakasis. And there is also a problem relating to the child labor. The question comes before us is that you also come across the instances of the child labor. For example, you go to a hotel, and a boy whose age is 12 years would come and clean your table where you wanted to sit, expecting the services from the server. That boy age is maybe 12 years, maybe 13 years, or maybe 9 years. So we usually keep quiet. And we don't raise any objection against the engagement of such child labor with that of the owner of the hotel. Now, what I just wanted to tell you to all the participants, to all the learned member who is taking part in this particular lecture and in the refresher course, saying that law alone will not serve the purpose, will not solve the problem that is being faced by the society. It is impossible. I think the positive effort and proactive effort of the people of the society is very, very important in order to put an end to the gross violation of human rights and a problem like child labor and the problem of untouchability. You know that the Thorat, Professor Thorat. No, you mean to say that what actually it is said that and what was actually prevailing in our country and carrying up a night soil, carrying up a night soil. Can you just imagine that? What is the carrying up a night soil? Carrying up a night soil because only few states and in that particular state, only few cities have a proper drainage facilities, Now, for example, in very rural areas and in some of the semi-urban areas like Dharwad, Hubli, or some other Gadag and all those things, drainage facilities, drainage system for a particular passage of your excreta has not been made. Behind your sandasa or behind your latrine, a ditch will be made and your excreta and your family member excreta will be filled with that, and a person after filling up that, if you engage in, he will come and clean it. Now the municipalities have been given authorities to clean it by using the advanced technology. Nevertheless, in villages and in town municipalities, such facilities are not there. Carrying up a night soil, you can just imagine that. Did you understand what I'm telling? Please make note of it. Carrying up a night soil. Night soil carrying means carrying the human excreta. ಮನುಷ್ಯರ ಕಕ್ಕಸನ್ನ ತೆಗೆದುಕೊಂಡು ಹೋಗೋದು. This is what actually it says, that even it is prevailing, and Karnataka is the first place, first state to abolish the carrying up a night soil during the B. Basulingappa period. When he was a revenue minister, he has come out with a very comprehensive legislations which actually abolishes carrying up a night soil. There are people. You mean to say that who are known as bungis. They are known as bungis. Especially these peoples are available in some remote areas of Gulbarga and Gadag and all those things, and they still carry the night soil of the feudalists who are living and resided in that particular village. And of course, there are many legislations that has been actually passed by the government. That's a different matter. But the question comes before us is that how best we can remove all these anathema, remove all these social sins. This is very, very important. And the other thing is that cleaning up utensils, as the case may be, or cleaning up the latrines. It may be public toilet, as the case may be. See, civic sense is very much absent in our country with the people. For example, public toilet is there. We don't know how to use it. And this is a matter of public importance too. And especially if it is a public toilet, we don't know, we will never flush it, as the case may be, it will flush it down. And our mentality is also like that. Also like that. Now, for example, I will give you one example. Now, for example, in your at your home, the latrine has been stuck down. And you're unable to, you're very much hesitant to clean your own latrine, as the case may be. You will actually engage a particular scavenger to clean it. He will come and clean it. And after that, this is my personal experience. Everybody starts actually bargaining with him. See, you feel that it's in a very dirty job and you refuse to do it. But what you refuse to do it has been carried out by a scavenger. But while after successfully carrying the particular work, you think that, hey, this is just a menial job. Let him give him 20 rupees. Let him give him 50 rupees, like that, as the case may be. So in the case of a cobbler, let me make it very important aspect. Now, your chappal or it may be your shoes that has been toned up, as the case may be. Now, you will go to a nearby cobbler who is sitting in the roadside. You will ask him to just stitch it, and he will charge 20 rupees or 30 rupees. Then you will start bargaining it. You will start bargaining it. Hey, what is the nonsense? For just one stitch and just one two stitch, you are charging 30 rupees. You take that chappal or you take that particular shoes to the showroom like a Bata, or to the Woodlands, or to the Nike and Asics. They will do the service and they will extend the service, but they will never charge less than 200 rupees. They will never charge less than 200 rupees. Or it may be 250 rupees, as the case may be, where you will never raise any objection there. Whereas when you take a service from the roadside cobbler, you start bargaining with him with a meager amount, That's what actually I just wanted to tell you here. It's not so easy for you to just look at the how you are actually meaning. Now the bonded labor system has been abolished way back to 1976, But it's not so easy. It is available, and here and there, even in the Mysore district, bonded laborers were identified very recently by the Tahsildar of HD Kote, and they just raided the house and the farmhouse, and they released him, and the cases have been actually booked against them. It is like that. See, one of the important question is that how best you can say that. Now, for example, I'm just going to refer some of the enactment. Prohibition of a manual scavenging that was enacted in the year 2013, as the case may be. And Bonded Labor Abolition Act that was enacted in the year 1976. Come back to the child labor. Make a reference to the MC Mehta versus Union of India. MC Mehta versus Union of India, a case which has been decided by the Honorable Supreme Court, where it was subject to some kind of a controversy because that was a petition was filed by the human rights activist MC Mehta, that those who are the children who are working in Shivkasi firecrackers factory must be insured for the 25,000 rupees. And this was actually a matter of a great controversy. This was especially a great controversy. The legal jurist like Upendra Bakshi and some other people, Akedawan, they have criticized it. Because, see, instead of abolition of a child labor, if the children who are working in the firecrackers factory is insured for 25,000 rupees, the interpretation goes like this, that the judiciary itself is actually encouraging the child labor by offering such a social security to the such child labor who has been engaged in firecracking manufacturing process. So it is nothing but actually many jurists felt that it is a gross violation of a human rights. Of course, the Honorable Supreme Court in its comment made it very clear that it is not so easy. It's not so easy to wipe out completely the child labor in India, and we have to do it step by step. We have to do it step by step. Like that, many such things are happening in our country as a gross violation of human rights. Now, coming to this, as the case may be, in our country, violation of a human rights, especially against the vulnerable section, especially against the women, usually based upon the caste factor. Usually based upon the caste factor. This is what actually I just wanted to tell you. Now the question comes before us is that when a woman belongs to Dalit family is subject to exploitations, no opposition can be expected from the society. You can make a comparison between the Nirbhaya case and I strongly oppose both the cases. That is different matter. That's a different matter. But as we have seen the opposition, the strike, the Hartal, and the demanding the entire government where the culprits are to be hanged till the death, and where there was a demand of, amending the Juvenile Justice Act too, amending the Juvenile Justice Act also. But the Verma Commission afterwards did not actually favor it. But the Nirbhaya case actually brought down certain warning to the entire society. And of course, across the country, there is a lot of opposition. Whereas very recently, when a Dalit woman in Hathras was actually brutally raped, and without the knowledge of their parents, when that victim was actually burned, there was no opposition. There was no actually strike. There was no such Hartal, as the case may be. That vigority was not at all there. It was very much absent, even from the Dalit community. And this is what actually I just wanted to make it very clear. In a country like India, where people are under, even this case, I just wanted to make it very clear here. In case of a Nirbhaya case, Women Commission, New Delhi, Sumoto has filed a case and registered the case. Whereas in case of a Hathras case, no such efforts have been made by the Women Commission of Uttar Pradesh or the Women Commission of Government of India, as the case may be. This is what actually happening. And there is no unanimity against the gross violation of a human rights. Now, what I just wanted to tell you is that when one human being refuses to treat the other as human being, this is a problem in implementing the various problems relating to the human rights. That's what actually my introduction, I made it very clear. Respect the people first. Respect the people first. As a human being, don't respect the people based upon their profession, as the case may be. If you does it, definitely there will be no such things will happen, and human rights will come to stay, and it will be a great moment in our country. Now, this is one important aspect. Now, the question comes before us is that in a country like India, the rape or exploitation against the vulnerable section, I am not telling that it is a Dalit or it's in a scheduled caste, scheduled tribe, it's in a vulnerable section, irrespective of the fact that whether they belongs to any caste, creed, and religion, and so on, as the case may be. So now here, that includes even the Dalits also. Now, the question comes, please mute it. Sunil, mute it. Okay, this is one important aspect. I have just wanted to, you can say that. I will give you one example of one case. R. Tata Desika Tata Chariyar versus Alagai Manavilla Zira Swami. This was a case decided by the Honorable Madras High Court in the year 1970. ನಿಮಗೆ ಇದು ಯಾವುದು ಕೇಸು ಗೊತ್ತಾಯ್ತು ನಿಮಗೆ? ಆನೆಗೆ ನಾಮ ಹಾಕಬೇಕು, ಯಾವ ರೀತಿ ನಾಮ ಹಾಕಬೇಕು ಅನ್ನೋದಕ್ಕೆ ಇದು ಕೇಸ್ ಡಿಸೈಡ್ ಆಗಿರೋದಿಲ್ಲ. That has become a very sensational case. There are two types of namas. One is Vadagalai Namam, another is Pengalai Namam, which claims by the two different subcaste of the same community who are the priest in the Kanchipuram Devasthan. This has become sensational. ನಮ್ಮಲ್ಲಿ ನಿರ್ಭಯ ಕೇಸ್ ಇದೆಯಲ್ಲ, ಹತ್ರಾಸ್ ಕೇಸ್ ಇದೆಯಲ್ಲ, ಅದಾದ್ರೆ ಏನು ತೊಂದರೆ ಆಗಲ್ಲ. Whereas it so happened about 25 years back in a Kolar district, Kambalapalli, where everybody was actually acquitted, where more than 13 Dalits were actually butchered by the feudalist, as the case may be. And that kind of a cases will never ever become sensational. Never ever become sensational. And this is a problem with each and everybody. And the other question is that, see, who is the most vulnerable section? A female child. That's what actually I have come out with some video clippings, but unfortunately we were unable to play it. Though who are subject to sexual exploitations, Very recently, a report has been placed in the House of the Parliament, also in the House of the Legislature in Karnataka, as the case may be. 75 to 80% of the sexual exploitation of the tender age female children have been reportedly done by their own close kith and kin. And the remaining 25%, 20 to 28% sexual harassment and the sexual exploitations have been reported by the outsiders. That means the solution is there in our home itself. And we don't know how to treat a child. And very recently, the United Nations under the UNICEF has given the directions. I mean to say that now when a small female kid comes to my home, how I am expected to treat her, what I am permitted to touch her. So I can touch only her head, or I can touch only her cheek, and something else, or I can touch only her hands. That's all. And to that extent, it is available in the United Nations website. Please go through it. But we are not at all expected to just touch various other parts, including the private parts, as the case may be. And unfortunately, this kind of a direction that has been issued by the United Nations organization has not been subject to very serious disseminations through the various literature. And this has been considered as a very ignored subject. This is what actually said that. Now, I just wanted to tell you that one important thing is that human rights, especially in India, is at stake. Because majority of the people are subject to gross violation of human rights. Maybe plenty of human things are there. I just wanted to highlight one more thing. Very recently, that report is available online. You please go through it. Very recently, Thorat was the ex-chairman of the UGC, ex-chairman of the ICSR, Indian Council for Social Science Research, has come out with an extended survey with respect to the availability of the untouchability across the country. Untouchability, the definitions that is available under the Civil Rights Act 1955 is different. The untouchability, the definition that is available under the so-called the prohibition of exploitation against or SCST Prevention of Atrocities Act passed in the year 1989 is different. But very recently, based upon the survey that has been conducted by Thorat, you can see that as many as 84 types of untouchability is prevailing in our country. 84 types of untouchability practice is prevailing in our country, which you cannot so easily be identified. So easily be identified, as the case may be. And even the government also cannot identify that it is an act of untouchability, and it cannot be covered under the purview of the SCST Prevention of Atrocities Act, as the case may be. So all such things are there. These are the very challenges of human rights that is prevailing in India. Now the question comes before us is that you say that human rights are universal legal guarantees protecting the individual groups against the action and omissions. This is very, very important from the point of understanding this. And you say that your rights are inalienable. It may be a basic rights, it may be fundamental rights, or it may be a human rights, where you cannot transfer it. But the question comes before us is that 50% of the total populations in our country are not aware about their fundamental rights. It is said that. It is said that. Now, for example, this is based upon the, we have done a workbook. Fortunately, I had a privilege of serving an institute called an Institute for the Study of a Social Exclusion and Inclusive Policy, where we have come out with so many research work very extensively, as the case. It may be the Paura Karmikas, or it may be the street vendors, or it may be the a particular community here in Chandrapatna of a Mysore district, Handi Jogis, as the case may be. Now, all they are very recently, we have also done some work on Bunde Bestaru. Bunde Bestaru, they are available in, of course, in Unsur Taluk, as the case may be. And they don't know. They don't know. You ask, now I have done a work on, investigative work on the Paura Karmikas. And we have gathered the first-hand data. And we just inquired the extent of knowing the enjoyment of the fundamental rights from them. They're not worried about it. They don't even know about the fundamental rights. ಮೂಲಭೂತ ಹಕ್ಕುಗಳು ಅಂದ್ರೆ ಏನು ಗೊತ್ತಿಲ್ಲ ಅವರು. They have been engaged. ಇಲ್ಲಿ ಏನಾದ್ರೂ ಸಮಸ್ಯೆ ಆದ್ರೆ ಯಾವ್ದಾದ್ರು ಟಾಯ್ಲೆಟ್ ಏನಾದ್ರೂ ಸ್ಟಕ್ ಅಪ್ ಆದ್ರೆ ಪೀಪಲ್ ವಿಲ್ ಗೋ ದೇರ್. ಇಲ್ಲಿ ಮಾಳ್ಮಡ್ಡಿ ಅಂತ ನಮ್ಮ ಮೈಸೂರು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಪಕ್ಕದಲ್ಲೇ ಇದೆ ಅದು. ಅಲ್ಲಿ ಅವ್ರು ಹೋಗ್ತಾರೆ, ಅವರು ದೇ ಜಸ್ಟ್ ಹೈರ್ ಎ ಪರ್ಸನ್ ಅಂಡ್ ದೇ ವಿಲ್ ಡೂ ಇಟ್ ಅಂಡ್ ದೇ ವಿಲ್ ಪೇ 100 rupees or 200 rupees. There ends the matter, as the case may be. So this is what actually it is said, that their conditions are very, very pathetic. And those who are doing the scavenging work, we have seen that a 35 years old woman looks like 75 years old woman because of the infections they are carried out by doing the scavenging job, as the case may be. ಈಗ ನಮ್ಮ ಡ್ರೈನೇಜ್ ಅಲ್ಲಿ ನೀರು ಬಿಡ್ತಾರೆ. ಈಗ ನಮ್ಮಲ್ಲಿ ವೇರಿಯಸ್ ಈಗ ವೆರಿ ಇಲ್ಲಿ ನಿಯರ್ ಬೈ ಇದೆ ಮೆಡಿಕಲ್ ಜೆಎಸ್ಎಸ್ ಮೆಡಿಕಲ್ ಕಾಲೇಜ್ ಇದೆ. ವಿತೌಟ್ ಎನಿ ಪ್ರಾಪರ್ process, everything will be released to the drainage, and as the case may be, these scavengers are expected to work there, and they get infected, as the case may be, and they don't know, because the corporation will never insure for their life, as the case may be. That means what I just wanted to tell you is that when they themselves don't know anything about the fundamental rights, whether that is being transfer to other person or not? I don't know. I don't know. They say that, no, sir, I don't know. I don't know anything about the fundamental rights. We wake up at 6 o'clock and we go for some scavenging work, and we come at 5 o'clock in the evening, and we drink and we consume some alcohol, and as the case may be, and we will have a sound sleep, and we will have it, and we will enjoy. And that is my life. And that is my life circle. They actually claim it. This is what actually says that. Is that the thing where in a country like India, where human values are being actually respected, or enjoying the human rights? Nothing like that, as the case may be. In a majority of the villages, when a woman or when a people belongs to vulnerable section visit a particular police station to lodge a complaint, it is not so easy. It's not so easy to expect the police authority to register the case. On the other hand, the Honorable Supreme Court says that provision has been provided for the zero FIR. I hope you all understand. What is zero FIR? Anybody? Anybody? There is an FIR. First investigation report is there. Of course, based upon that, the preliminary investigation has to be done. And then if the prima facie allegation made by the complainant, then the FIR may be charged. That is different matter. What is zero FIR? And it is based upon the direction given by the Supreme Court, where there is an absence of the jurisdiction. So for example, you go to a particular place, Delhi, you lost your belongings. Whereas you go to nearby police stations and you wanted to lodge a complaint. They say that from where you are. Sir, I am from Karnataka. Then you cannot, the police station cannot actually say that I will not actually lodge a complaint, and the FIR cannot be actually registered, as the case may be. Wherever he may be, from, that is, it doesn't matter. The police authorities are expected to take the complaint, and if the prima facie, if it is worth enough to be FIR, and by giving the zero, number, they have to register the FIR, and then after the preliminary investigation, they need to actually send that particular complainant to the particular jurisdictional police stations for the further investigations, as the case may be. It is there, and of course, but it is feasible, it is possible only when the law is accessible to the people. Only when the law is accessible to the people. I don't know. I may be a law professor. I can say that. But an ordinary layman cannot understand. A villageman cannot directly so easily or without any fear enter into the police stations. It cannot be possible. You cannot expect him. Then it says that. On the one hand, the Constitution says that your fundamental rights are inalienable. But I myself don't know what is the extent of the fundamental rights. What is the extent of my human rights? What is the extent of my basic rights? What is the extent of my inherent rights? I myself don't know. Then how can I protect myself? As the case may be. And of course, on many occasions, the court says that. No, we have come out with it because there is a liberalization of a locus standi. There is a liberalization of a locus standi, as the case may be. You can just see that. Here. Right. The other question was that the malnourishment. So how to overcome the malnourishment? So in a country like India, majority of the people expect everything from the government. So it says that very recently, in the year 2000, the Supreme Court says that malnourishment and is a national shame. National shame. Then it says that the series of directions have been given. One of the participants in this particular session has submitted his thesis on the right to food, critical analysis of the Food Security Act 2013, a case study of Mysore district, as the case may be. My student, his name is K. Ramesh, as the case may be. Then, owing to that, for example, in the PUCL versus Union of India, and which says that the case which has been decided in the year 2001, as the case may be, the Supreme Court held that the malnourishment is a national shame. The malnourishment is a national shame, but a majority of them are like that. So, how to overcome the malnourishment? How to overcome the? So, the expecting mothers, the pregnant mothers, it should start when a woman got conceived. The government is expected to take care of it. And when a woman declares that she is a pregnant, then the government is under obligation to nourish her in order to overcome the malnourishment, as the case may be. It's in a very long process. It's not happening. Very recently, more than 750,000, it is reported that the children are subject to malnourishment. So this is what actually it says that. So the rights, as the case may be. The human rights, if it is considered as a negative right, then I feel that it is very safest interpretations. Please make note of it. The negative right, the negative duty are similar to the nature. So the negative duty means where it will actually prevents the interpretations or interference by the other persons. So instead of claiming the human rights as a positive right, if you claim it as a negative right, I think more proper definitions can be given to the phrase called human rights. Then I just wanted to make it very clear that when you go to the historical evolutions, thanks to the Romans who have conceived and who have gone the jus civile and the jus gentium. Jus civile and the jus gentium. You know that about 3,000 years back, jus civile means a law for the civilians. Jus gentium means law of the nations, as the case may be, where the Rome come out with a legislation that the foreigners cannot purchase a property in the Rome, and such legislation was introduced, and the entire advocates, entire lawyering community actually boycotted the courts in that particular country, and there the jus gentium was actually came into existence. It says that. See, law should be unequivocally available to each and everybody, irrespective of the fact that whether they are a citizen or a non-citizen, whether they are the citizen or a non-citizen. And this has been made very clear that under the Article 21 of the Indian Constitution. India is a third world country. Dr. B.R. Ambedkar was the father of the Indian Constitution, was very much aware about all those international instruments, including the
Mysore ಮಾತಾಡ್ತಾರವರು ನಮ್ದು ಇಲ್ಲಿ ಗೊತ್ತಾಗತ್ತೆ ಅದಕ್ಕೆ
Hello, Zos, my audio off ಮಾಡಿ Zos.
Hello. Mute madre. So the question comes before us is that, please see that your computers are muted. Otherwise, it will take a deviations. So now here, Ambedkar was always known all the international instrumentalities, various conventions, including the United Nations, UDHR, Universal Declaration of Human Rights, as the case may be. He wanted to include it. That's why you just make a reference to the Article 14, 15, 16, 17, 18, and Article 21 also. Some of the articles says that those rights are exclusively claimed by the citizen. For example, Article 14 is unequivocally available to the non-citizen also. Nobody should be discriminated based upon the caste, creed, religion, and so on. Whereas under Article 21 of the Indian Constitution, it is very clearly stated that no person shall be deprived of his personal liberty, life and the personal liberty, except in accordance with the procedure established by law, as the case may be. It is even today, it is not yet decided. It is not yet decided when you make a reference to the Magna Carta, or when you just make a reference to the amendment, that is the 13th Amendment and the 14th Amendment made to the US Constitutions. And even today, there is a confusion that whether the procedure established by law is equivalent to the due process of law or not. You can just make a reference to it. It is very, very important. I don't know whether the previous speakers have touched upon this particular issue or not. And this aspect has been very clearly discussed in the A.K. Gopalan versus State of Madras, where A.K. Gopalan, in that particular case, it was argued that the procedure established by law is equivalent to the due process of law. But the first ever independent India Chief Justice, Justice Kania, says that due process of law is not similar to the procedure established by law, as the case may be. And even today, even this particular confusion was again discussed in the Maneka Gandhi versus State of Union of India, as the case may be. And the clarification has not been so easily be offered by the so-called the Supreme Court. It is entirely different. That's why they say that due process of clause is entirely different from the procedure established by law, as the case may be. Now it says that Magna Carta, petition right 16, Magna Carta 2015, petition right 1628, Montesquieu, a spirit of law in year 1748, French revolutions. This is where actually the spirit of laws is the base for the French revolutions, abolition of monarchy and the establishment of the secular democratic country. And then in India, it's a Pune Pact. Where it is said that the vulnerable section should be given some adequate representations, and special provisions must be made in the various enactment that can be made by the government of India. Ultimately, it is in a Hindu Code Bill. 1952. It's not actually 1950, it is 1952. Of course, Hindu Code Bill has not been placed, strictly speaking, because there was a lot of protest across the country. I'm astonished to know that when I just know the literature with reference to the Hindu Code Bill, because Hindu Code Bill was ensures the great reformations in the Hindu religions. And it's in the greatest emancipation of a woman, greatest empowerment of Hindu women. But unfortunately, women themselves opposed the Hindu Code Bill during the 1950s. That is the pathetic conditions. Now, the main intention, the main purpose of the Hindu Code Bill is being implemented by piecemeal. Very recently, Hindu Succession Act was actually amended in the year 1996, where you can say that the property share can be equally enjoyed by the women as the case may. That is the offshoot of the Hindu Code Bill, if you want to say that. That is the offshoot of the Hindu Code Bill. And you may believe it or not, before the enactment of the Hindu Marriage and Divorce Act 1955, woman was not empowered to give the divorce against her husband. You can just make a reference to the section 11 and the section 13 of the Hindu Marriage and Divorce Act 1955. So polygamous marriage was prevailing. A person may marry as many as a girl he wanted, but whereas a woman was unable to give divorce to her husband for any reason for the matter. You say that this was actually said by Ambedkar that this is a gross violation of a woman's right in India. And he wanted to establish, and he wanted to take the support of the Article 14 of the Indian Constitution. Unfortunately, this could not be materialized. So easily. But what to do? Then, when the Hindu Code Bill was not placed in the House of the Parliament, when the Nehru government refused to place the same in the House of the Parliament, owing to moral responsibility, Dr. B.R. Ambedkar tender his resignations and come out of the government, as the case may be. And this is what actually it says that. But the efforts made by Ambedkar through the Hindu Code Bill, then you can say that you can log on to the Google or you can log on to the Shodh Ganga. Please make note of it. Let me make it very clearly. You can log on to the Shodh Ganga. So there are more than 200 theses that have been actually produced based upon the Hindu Code Bill in our country. And this has been actually considered as a most important and relevant bill in the country, where you can also make a reference to the Bill of Rights of US, Bill of Rights of UK, as the case may be. But the question comes before us is that it is not so easy. It's not so easy. It says that incidentally, not accidentally, the term secular and the term socialism is also part and parcel of human rights. It is said that. And the interpretation goes like that. Please make note of it. The interpretation goes like that. Because if a country is not secular, then human rights cannot be so easily be protected. It cannot be so easily be protected. Let me make it very clear by making a reference to the Establishment Clause, where you are expected to make a reference to the first amendment made to the US Constitution. Establishment Clause. It is known as lemon test. Lemon test. Lemon versus herds, as the case may be. Wherein the first amendment made to the US Constitution says that, please make note of it, Congress shall make no law for establishing any religion in the entire US. The other part actually offers the protection for the freedom of speech and expression. You can see, it is available on the net. It is available on the net. Whereas it says that Congress shall make no law for the establishment of a religion. It does not mean that the government has been prohibited to promote the religion. That is the interpretation. Establishment, they cannot. They can't. That's what actually in the Article 25, 26, 27, 28, and 30, it has been made very clear. It has been made very clear. Whereas when any financial assistance is given to any trust established based upon the minority, normally minority and ಏನು ಅಂತಾನೆ ಗೊತ್ತಾಗಲ್ಲ. The definition itself is a very confusing, as the case may be. There may be a democratic minority, there may be linguistic minority, and there may be any other minority, as the case may be. Everybody wanted to take the shelter under the constitution, and nobody wants to abide by the constitution, as the case may be. This is very, very important. So now the question comes before us is that you can just keep on go for it. What are the three generations? Now it is at the fourth generation is also of human rights is also coming. First generation, as you said, that we used to struggle for the civil and political rights, and the second generation we used to struggle for the economic and social rights, including the employment and housing. Housing is a human rights, and of course, majority of people have been deprived of getting the housing. Proper housing is not provided. And of course, many such policies have been actually made. And the third generation says that right to development and cultural right. And the third generation human rights is exclusively dependent upon the first and second generation human rights. Human rights, as the case may be. So the first generation human rights, the second generation human rights, the third generation human rights. Let me come back to you make a reference to the establishment clause, the Lemon test, as they call, making a reference to the First Amendment made in the year 1726, as the case may be, 1797, as the case may be. Congress shall make no law for the establishment of any religion, and Congress shall not actually deliberately support any religious institution, as the case may be. If it is support, then that institution must be treated as a state, and based upon the caste, sex, race, the admission cannot be actually given. That's what actually it is said. Now, way back to the last part of the 18th century, the similar situation is also available in our country. It's also. Let me make it very clear in my next lecture. I will tell you that the term secular is a misnomer. The term secular is a misnomer, and nobody comes to say that. And it is said that even if you make a reference to Article 25, 26, 27, the term religion has not been explained and defined in the Indian constitutions. It's a question of faith. It's a question of faith. So I have a faith. That's all. And for example, who established the Hindu religion? Who established Buddhism? I don't call it that Buddha will never establish a Buddhism. Actually, Buddhism itself is not at all a religion at all. It's a way of life. And on many occasions, the court says that we cannot offer any exact definition to the term religion. We cannot actually offer, because it's all depending upon the faith of an individual. Faith of an individual. It is like that. I, being a Hindu, I can go to a church, I can go to a mosque. Nevertheless, I can claim that I belong to Hindu. A person belongs to Islam who is a Muslim, He can go, he can come to the temple, offer a prayer, and he can go to church, offer a prayer. There is nothing like that. That's why I just made it very clear that. But the term secular is an incidental factor for the glorification of the human rights. Just imagine that. If the people do not discriminate or treat on the basis of the religion to which they belongs. Let me make it very clear. If the people of a particular sect do not treat or discriminate based upon their religion, and there will be no communal rights. And there will be no unrest in the society. There will be no unrest in the society. And there will be lot of scope for the law and order. If there is a law and order, if the presence of a law and order is ensured by the state, then I hope and I think that human rights will not be subject to violations. And there will be no violation of a human rights. That means a secularism, the concept of a secular is an incidental to the glorification of the human rights. Emancipation of the human rights for the purpose of respecting each other. That's what actually it says. We are struggling that because if you make a reference to second generation and the third generation human right, you can say that what is development? And then again, you can say that what is the difference between the growth and the development? Whether the development is depending upon the growth or it is vice versa or not, as the case may be. Now it is in a cultural right. The third generation cultural right says that. Now we mean to say that food is a culture. Food is a culture, as the case may be. So whatever is available, and that I can take it. But that is being objected. That's a gross violation of human rights. So now here, the development and the growth. What is a development? Whether is it a change in my economic conditions? Or is it a changes in the social status? And there is nothing like that. And even the term development is interlinked with that of the poverty. And the UNDP, United Nations Development Program, offers the definition to the poverty, saying that when a person is unable to access to the essential thing, then that is known as a poverty, and that person is known as a poor person. For all these things, the government support is very, very important. That means we are still struggling for the basic rights. We are still struggling for the basic amenities. Then we can think about the growth. Then we can think about the development. Then it is said that you can just, this is what actually it says that based upon the data, you can just say that in a market, you go to a coolie, a hamali is there. Hamali is there. You go and ask him. Hey, do you know what's your right and what's your human rights? He will just ridicule at you. He will just laugh at you. Hey man, go. I am earning my livelihood for the day. I am earning my livelihood for the day. That is sufficient. What the hell with your human rights? What the hell with your basic rights? As the case may be. Because of the ignorance. And on the one hand, you say that ignorance is no excuse. But who is expected to give education to them? It's the government. It's a complete lapse on the part of the government. That's why for the protection of the human rights, for the establishment of the law and order, for the Protection of a life and the property of an individual. This is very, very important, as you can make a reference to the Article 21 of the Indian Constitution, saying that Article 21 says that protection of a life and the property is very, very important. And again, you say that life is greater than that of the property. And the property can be enjoyed and possessed by any individual, including the saint, the head of the mud, head of the temple, as the case may be. It makes no difference. It makes no difference. On the one hand, the philosophical interpretation says that a saint means one who forgo everything. But here in the 20th century and the 21st century, we have witnessed that the person saint or the head of the mud, they are the richest people on the earth. You can just make a reference to various head of a mud, as the case may be, or a saint like that, as the case may be. They're all the owner of the so-called medical colleges, engineering colleges, and pharmacy, and as the case may be. No, what I just wanted to tell you is that the human rights concept is very, very important, but it is dependent upon the how best you reciprocate with the efforts made by the state. Efforts made by the, I just made a reference to the child labor. I just made a reference to the untouchability. I just made a reference to the bonded labor system. I just made a reference to the what we call that the sexual harassment of the so-called the tender age girl. And I just made a reference to the malnourishment. Government is doing a lot of things through its policy, spending crores of rupees, as the case may be, but for the removal of the untouchability, for the removal of the bonded labor system, and for the removal of the various other social sins, the societal proactive is very, very important. If it is not there, it is very, very impossible. These are all the challenges. I just wanted to make it very clear. If there are any questions are there, you can ask me, please. One question. You can ask the questions.
Sir, good morning, sir. This is Dr. Nagashishma from Government Law College, Kola, sir.
Tell me.
Can you hear me, sir?
Yeah, I can hear you. Please tell me, ma'am.
Sir, you have done a pilot study with regard to this Shivakashi case, no, sir, Shivakashi, with regard to fireworks, sir. There, I went somewhere, I mean, long back, and the
long back means when? You tell me the date.
Sir, when I am doing LLM means it is 15 years back, sir.
15 years back, huh? What's your age, madam, now?
Sir?
What's your age, madam, now? No, I don't know. I'm not inclined to ask, but because I must know that.
No. What
okay, that's not disclosable. Okay, madam. 15 years back, you
had
been to...
like that, sir. When I did my LLM, so in the new day, so I went there, and there the things means the agents are taking these children to the workplace.
Mediators.
After that, you visited, no, sir. What is the situation? That I want to know, sir.
Madam, this is very pathetic. They are unable to express their problem. Then
no, sir.
they...
See, what is...
No. A tempo will come. A tempo will come.
Same situation only.
Yeah. The tempo will come. They dump the children and the parents also like a cattle, and they take you to a particular destination. So where that the firecrackers are being manufactured, they will be served with 3 or 4 idlis, and of course water will be there. And of course that's in a portable. It is as we have said that, and we learned that it is not potable water. And of course, they are not worried about whether it's a portable or not. And as the case may be, and minimum wage wages was also not being offered to them. Now the question comes before us is that, madam, legally speaking, whether the Minimum Wages Act 1948 as prescribed by the government, is it applicable only to those laborers who have crossed 18 years, or is it applicable even to the child labor or not? Thank you, ma'am.